Welcome to Notable Approvals. I am attorney Amanda Shaffer. If you joined us last week or earlier this week, you know we've been focusing on asylum and withholding notable approvals. That is in anticipation of our live Q&A discussion on asylum and withholding removal that attorney Aaron Shapiro and I will be co-hosting this Thursday, September 24th at 9 p.m. Eastern Time. Like us, follow us. You don't want to miss it. Send us questions in advance. We'll answer your questions live. Today, however, we're going to take a quick break from asylum and withholding removal to talk about a case that we just got approved that I'm really, really excited about. And this is a case that took almost 3 years for something that should have taken 90 days according to the law. And I'm going to go through the facts of this case, and that we eventually had to get to the point where we sued the federal government. And that's how we got this case finally decided. So to start, we'll go through what happened and why this case was such a monster. So our client's a native and citizen of China. She initially entered the US in 2008 as an F1 student. She graduated college, left the US, and then came back as a student in 2013 for grad school. In 2015, March 2015, she met her future wife. They started dating, and then in February of 2016, she got married. Her spouse filed an I-130 for her. Since she is a US citizen, my client was able to concurrently file an adjustment of status application. And there were some red flags in this marriage before they got married and before she got her conditional green card, but nothing that my client really didn't raise the red flag until after the fact, and which is very common, unfortunately, when you're dealing with an abuse case, as we are in a situation here. So her wife actually worked for the police. So she was a cop. So she had a gun, which is very intimidating. And she also had some OCD and basically, she didn't treat her very well. There was a lot of verbal abuse. She cut her off from her friends and family. She was a very jealous person. She didn't even want someone like walking between them. And it seemed like a lot of this stemmed from her not being comfortable with her own sexuality. She asked my client to go with her to Cancun to go to a wedding. I don't know why there's a bug in here. A wedding of one of her coworkers. And she made my client stay in the room the whole time, even though she came down to Cancun with her. So obviously, she had a lot of issues, and she took it out on my client. And February 2017, the conditional green card was granted. The relationship breaking point came in July of 2017. My client and her wife went to Spain for a vacation, and that is when the verbal abuse turned physical. Her wife ended up leaving her in Spain by herself and like went home early. When she got back to the US, this was like beginning of August of 2017, her wife immediately moved out and a few days later filed for divorce. And that is when our client first came to us, when she got served with the divorce papers. Now, in New York, you can have an uncontested divorce, which means that there's no issues that you're fighting over. You're not no maintenance or spousal support, no assets to split up, no children to pay child support, no custody visitation, unless that stuff was already settled. They didn't have kids together. They didn't have assets together. So she did get served with an uncontested divorce, but when she brought it to us, the divorce was filed on the ground. That's from the DRL section 177 in the New York law, which is based on an irretrievable breakdown. More specifically, the marriage has been irretrievably broken for 6 months. Now, when she saw this, the marriage, she kept thinking that the marriage was going to be fixed. But when she got served with these papers, and we look at the date, it's August 2017, 6 months earlier is February 2017, when she got her conditional green card. So we said to her, you can't just sign the affidavit of defendant agreeing to the divorce because you haven't been broken up for 6 months, and immigration is going to think you lied at your interview. So we said to her, why don't you have evidence here of abuse. Why don't you file a counterclaim based on abuse? Now, a divorce based on abuse is not required for the abuse waiver for the I-751, but it helps, obviously, but she didn't want to do it. She was scared. She was scared it was going to hurt her spouse at work, and that, again, her spouse had a gun, knew where she was. That was very intimidating for her. So we didn't counterclaim on that. And we said, well, at least go get yourself a family court order of protection. It was the same reason. She really didn't want to create any problems for her spouse at work. That's not needed either, although highly, highly recommended, especially when there is physical abuse and your partner has a gun. Anyways, so we said to her, look, this is what we have to do. We looked up the law, and it said, even if somebody says, no, my marriage has not been irretrievably broken for this entire time period, the court has ruled that only one party needs to swear under oath that they've been irretrievably broken for 6 months. So even though we had an email from her wife saying, hey, obviously it's in beginning of August, it's clear now that our relationship is not going to work, I'm moving out, etc. That didn't matter. But we still had to have an inquest. So I represented her in the divorce. We went to court, and basically the judge asked, is it true that your marriage has been irretrievably broken for 6 months? We said no. She said yes. And the judge says, we're only required to have one party, blah, 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 granted the divorce. Fine. When the divorce was granted, before the divorce is granted, we immediately filed, as soon as we could, in November of 2017, the I-751 waiver based on a marriage that was entered into in good faith, but ended, but she was a victim of battery and extreme cruelty during the marriage. We couldn't file on the divorce ground yet, because if you file based on the divorce waiver ground and your divorce isn't final, you're going to get a request for evidence. And if you get a request for evidence, you're going to have 87 days to respond. And if your divorce is not complete in 87 days, you're going to get a denial. So you can change grounds, which is what we did. Excuse me. So in, I think it was, let's see here, August, so the divorce was final June 2018. August 2018, we send in a request to change grounds from abuse to divorce. The reason we wanted to change grounds from abuse to divorce is because both of those waiver grounds, you have to prove that the marriage was entered into in good faith. That wasn't a problem. With the abuse ground, you have to then prove that you are a victim of abuse. Whereas the divorce ground, you just show them the divorce decree is final. So even though we felt we had strong evidence of abuse, we didn't have a court order of protection. We didn't have an arrest. We didn't have some of the things that would have made it stronger for the reasons I stated. But so we felt it was just easier. We want to make sure this gets granted. Let's switch it to divorce. USCIS never responded when we filed it. And in fact, it was December of 2017 when she did her fingerprints. The only other communication we had from USCIS was they sent another extension notice. So at first, they extended her conditional residence for a year. And then I think in April of that year, they extended it for 18 months because they were taking even longer to process them. So we're waiting. And we start the process of contacting USCIS and going through all the hoops to try to get somebody to do something on this application. So my client called USCIS, the 1-800 customer service number. She called twice in December 2018, once in January 2019, 2 times in February 2019, again in October 2019, and then twice in June 2020. Each time she called, she was told that your application is still pending. We can't give you any information or time frame. Not very helpful. But important to note that if you're in this situation and you're calling about your case, every time you call, you need to record the date that you called and there's like a referral ID that they give you, like a number. You need to write that down, and I'll get back to later why you want to have that information just in case. So she did that. She kept calling them, nothing. So then we started filing case status inquiries online. We filed one in August of 2019 and then again in October of 2019. No response from USCIS. Because the waiver was initially based on abuse, it goes to the Vermont Service Center. That's where it's decided the divorce waiver would go somewhere else, to a different office to make that decision. So there's a special follow-up line, like email, that attorneys can send inquiries to, which is with the Vermont Service Center. So we sent one to the Vermont Service Center. Actually, we sent an email twice, no response. So the next step is the Ombudsman case assistance. Now, the Ombudsman is this like office that is part of, I think it's part of USCIS, it's part of DHS. I'm not sure exactly what it's a part of, but what it kind of like helps you with problems. So if you can say to them, hey, my case is taking so long, it's outside processing times, they'll contact USCIS, look into it, and hopefully give you some helpful information on what's going on, although not always the case. So we filed it in December of 2019. In April of 2020, we finally got a response, and they're supposed to, I think, in 90 days give you a response. But we finally got a response, and they said, well, yeah, this is taking a long time. We're going to contact USCIS. Great. May 1st, they get back to us again, and they say, we contacted USCIS. Your case is under active review, and we can't give you any more information. So we're like, all right, well, now what? Well, we also told our client to contact her local congressman, because all the congressmen and women have in their office a person that's called like their congressional liaison to USCIS. And this person's sole job is to help constituents with issues like this. And when something's taking so long, there's a special person at USCIS they contact and get immediate information, immediate feedback from. So in January of 2020, my client reached out to her local congressman and explained the situation. And at first, the liaison said, we contacted the Vermont Service Center. They've been adjudicating petitions that were filed on or after August 2018, which was after my client filed. And so she's like, since it's filed pending longer, I'm gonna reach out to USCIS again. February 2020, we get another reply, and this time we're told that the security checks are pending. And that was the issue and the holdup, but no time frame could be given. So at this point, we had already brought up to my client that if we get to this point and we still don't have any correspondence or answers, then there's this like end of the road solution called the Writ of Mandamus. And what a Writ of Mandamus is, it is when you're literally suing the federal government to act. You're saying that you have a duty to act and you need to carry out your duty. And I have a right to this. And I'll go through exactly what the elements are in a second. But essentially, we had been talking about it for a while, and we kept kind of putting it off, hoping we'd get a response, because it's a real federal lawsuit filed in the Southern District of New York. So what we decided to do first was draft the writ. Instead of filing it, we emailed it to the director of USCIS, and he said, look, we'll give you 14 days to do something with this case, or we're suing you. Nobody responded. So the first question with the Writ of Mandamus that you look at is, well, what are you suing under? So there was two statutes we were suing under: the Mandamus Act and the Administrative Procedure Act. And then we had to say, well, who are we going to sue? And that part of that question is answered by where is your application located. We ended up suing 9 different entities. So we sued USCIS, Director of USCIS, Vermont Service Center Director, the FBI Director, Department of Homeland Security, Secretary of Department of Homeland Security, Attorney General, and I think I'm missing somebody, and the Vermont Service Center. So we sued all those people. The reason we had to include the FBI is because the congressperson had said it's the FBI is the one who does the background checks, and they're the ones who we're waiting on. So that meant we had to draft a complaint and then manually serve it on all those people. So in order to bring a writ of mandamus claim, there are 3 elements you have to prove. 1, that you have a clear right to the relief sought. 2, that the defendant in question has a duty, the defendant has a duty to act, in what you're saying they have that duty for. And then finally, that there's no other adequate remedy available. Under the Administrative Procedure Act, you have also 3 different things you have to prove. You have to prove, number 1, there was an unreasonable failure to act. Number 2, oh, I didn't put this that way, I'm sorry. So you have to prove there was an unreasonable failure to act and that this violates your Fifth Amendment right to due process. A failure to act is an agency action. So the fact that you have to be able to show that there was an agency action to begin with that you needed done. And we had to also show that USCIS was in possession of all the information it possibly needed to make this decision. So when you go to sue the federal government in this writ of mandamus for not acting on an immigration application, each application is going to be different because you have to look at the statute to see, first and foremost, like this duty to act. Is it discretionary or mandatory? And then it's mandatory if you file this application, they have to act. And then the next question is, what is the time frame they're supposed to act in? So you have to be able to point to that. Now, there are some statutes for the immigration applications where it doesn't give a time frame, and this writ of mandamus may fail. And so it all depends on that individual benefit that you're applying for. So when I wrote the writ, I walked them through the facts of the case, how I did earlier. I went in a little more detail. I explained what was submitted for each application. Like I kind of like listed for like, okay, this is the marriage evidence that was submitted. This is the abuse evidence that's submitted, et cetera, et cetera. Then we had to show that we showed there was an exhaustion of administrative remedies. And that's when I went through all the different ways we contacted USCIS. That's what that is. Now, for an I-751, there's no specific requirement that you exhaust administrative remedies. However, it's a good idea to do it, and it's highly recommended. So we literally did everything you can do on that list of what happens when my application is taking so long. And we got no help, and that's why we needed the judge to help us. That's why we filed the lawsuit. So the next thing we had to do is pick a venue. Now, there's a couple different ways you can pick a venue in federal court. One is where the plaintiff is located, one is where the defendant's located, and one is where most of the acts related to the case took place. In this situation, when our client first came to us and we filed the I-751, she lived in New York. The divorce was in New York, the marriage was in New York, everything was in New York. A year and a half later, still waiting, she moves to New Jersey. Now, Aaron is, what's it called? Registered, I'm losing the word. Registered in the Southern District of New York. I'm licensed. License is the word. There you go. He's licensed in the SDNY, EDNY, and Second Circuit. I'm just in the Second Circuit. I'm licensed to practice law in New Jersey, but I'm not admitted to the federal district court in New Jersey. So we chose to file it in the SDNY, one, because it was easier for us. I could have gotten admitted if I needed to be, but also there's a difference in case law. So I had to look at the Third Circuit case law and the Second Circuit case law and see, do we have a better chance of succeeding in one or the other? And the Second Circuit seemed to be a better fit all around. Then we had to show the statutory duty to adjudicate the petition. If you look at the Immigration and Nationality Act, or INA, for the I-751, it says when you file it, the government has 90 days to either interview you or waive the interview. If they waive the interview, they have to make a decision in 90 days from the day that they waive the interview. Now, in this case, obviously we had been waiting a lot longer, and anyone who's watching this and has filed an I-751 and got it approved may be looking at me like 90 days. I'm making that up. That's a joke, right? Because these things, why did they give us these notices? It's going to take at least 18 months. You're right. Because that's what the law does say, the 90 days. But because of the reality of the situation, it's not common that it gets decided in 90 days. So we also then look at administrative processing times, current administrative processing times. And when we looked at that, and I actually submitted the screenshot from USCIS website, it said that these I-751s were taking 10.5 to 17.5 months. But the time that I looked at it, my client's case was pending for 32 months, which is more than 100% more of the time it should take. So I had to put that in the writ. I had to attach the proof of that as well. So I filed the writ on August 12th of this year. And then I served it between August 21st and August 24th. And I say between because there were a couple of parties that it was recommended that I also email a copy to. And I think that's kind of also what sped some of this up. And I had to mail it out. I had to have 9 different piles of paper and exhibits and exhibit tabs to mail out to all the parties. So I made sure to do the emails first. And then on August 24th, there was the date of the interview notice that we ended up getting for the interview on September 15th. Remember, we hadn't heard from USCIS since like August of 2018 when they were like, okay, 18-month longer extension. Now all of a sudden we file this thing, and like literally a few days later, they scheduled my client magically for an interview. So I did attend the interview with her telephonically because of COVID. She had to go in person. And it was a good thing I was there because I had to explain, which I figured, the divorce situation to the USCIS officer. And then the interview went great. But of course, given everything that had gone on, we didn't talk about the writ at the interview. But at the end of the interview, which I never hear from the USCIS officers, that we're definitely going to have a decision in 90 days. And I said, okay. So we left there, and I told my client, look, you're getting approved. I could tell it went great. It's just a question of how long it's going to take. And, excuse me. So what was I saying? How long is it going to take? I just lost it. Well, this is the most exciting part, so I'm a little excited about this. Anyways, so yes, the only question was how long it would take. Oh, what to do with the writ, duh. Okay, so my client says, what do we do about the writ? Like, are we gonna withdraw it? I told her, scheduling you for an interview is not a decision. We're suing them to make a decision. So we have to wait now. And I was like, I'm not 100% clear now if they get a full new 90 days, but it's supposed to be 90 days from the day you file your complaint, the government has to respond, which is different than the 90 days from the date of the interview. So it gets a little confusing. I was like, but let's just hope that we don't need to know the answer to this. And they decided quickly. The next day, my client checked online. It was approved, finally. And then after all this time, I actually held her green card in my hand today. And not only was it approved on the ground that allows her to file for naturalization based on the 3 years of marriage, because it was granted on the abuse ground, not the divorce ground. We had this conversation with the officer. I asked her, well, what ground are you going to grant it on? And she's like, well, I can only put in one. What do you want? And I was like, well, we want it granted. So if you think there's enough abuse evidence, then the abuse, so she can get her citizenship. She's been waiting. And she then asked her a couple more questions about the abuse, felt that it was sufficient, and granted it. So we are extremely excited about this for our client. She's actually already here waiting for me to give her a nice big COVID socially distanced hugged. And yeah, the Writ of Mandamus was a beast. And now that we actually have the real approval tomorrow, probably tomorrow, it's already 3:30ish, I'm going to have to file a motion to withdraw with the federal government. I'm more than happy to do it. I'm just really excited that it worked like that. I was nervous about it. It was the first time we ever got to that point where we had to file it. And lately, a lot of people are getting closer and closer to that point because of COVID and everything going on. And anyone who is watching out there, that wanted a copy, well, we'll talk about that later. Regardless, that's all I have to say about this case. I thank you all for watching. If you have any questions, feel free to contact me. And as a reminder, on Thursday at 9 p.m., my co-host Aaron Shapiro and I on Facebook and YouTube, we will be live for a Q&A discussion on asylum and withholding of removal. You can send us questions in advance or ask us questions live. We hope to see you all there. And don't forget to follow us on all the Facebooks and stuff so that you don't miss any more. Thanks for watching.